Hey guys, welcome back to today's video. We've got two sovereign citizens appearing in court. The first is a follow-up to a case I covered previously, and the second involves a situation I haven't seen before, but I'll explain more once we get to it. So, without further ado, let's jump right in.
Court will call People versus Robert Geese, 26T884. If you'll come on up and have a seat at the table. And then I show we have Ms. Morissette and Ms. Shireman for the People. All right, so I show that we're set on for a motions hearing. I don't show that there were any motions. I believe the motions that were previously filed had to do with obtaining discovery. Is that correct, Mr. Geese?
Yes,
Okay, and how do I say your last name?
it is Geese.
Geese,
I
okay.
think Canada,
Okay.
excuse me, Canada Geese.
Okay. All right. So I have not received any endorsement of witnesses or defenses for your case. So I take that to mean that you won't be calling any witnesses other than possibly testifying yourself. Is that correct?
Your Honor, thank you, first of all. Good afternoon. I filed the motion for discovery, and there are 6 points, actually 7, but 6 points within that motion that have not been answered. And I also filed an affidavit of truth, and that has not been answered. Therefore, I don't understand how the court can move forward. I do want to correct the record on a couple things, if I may. Do I have your permission to read this into the record?
So let's go back to the question that I asked first. Are you going to be calling any witnesses? Because you did not file any endorsement of witnesses.
I don't know how we can move forward calling any witnesses without answering the motion and affidavit that's before the court presently.
Okay, why don't we start then with your motion for discovery? What exactly is it that you're claiming with the motion for discovery?
Do I have standing to read this into the record, first of all?
You don't have to ask for standing, so.
Thank you. Respectfully, for and on the record, I am Robert Geese, a living man of the Union, a non-belligerent or enemy of the state, and I occupy the office of Executor and Co-Trustee for the Nole Me Concare Express Trust. I am here propria persona in that regard, not pro se, by special appearance only, not generally. Further, I'm of the age of majority by both the age.
Can I stop you for just a second? I am not going to consider claims that you're saying that I can't proceed on the case because you are not a citizen or anything like that. We're not going to proceed that way, okay? So did you say that you had some actual discovery issues that you needed to address?
Your Honor, respectfully, am I being denied my due process rights of being able to read this into the record?
You can file whatever you'd like, but no, I'm not going to sit here and listen to you just read a document into the record, okay?
I object.
Okay, that's fine. So did you have any actual discovery issues for us to address?
The discovery I filed, it's in writing. I don't know that it's necessary to sit here and read everything into the record. You just said that you don't want me reading into it, and now you're contradicting that with something else.
Have any actual discovery issues? Is there some part of discovery that you believe that you have not received?
All of it. Nothing's been answered.
Okay, so this is not a situation where they have to answer questions, okay? This is not a civil case where you get to do depositions or ask interrogatories. As part of a criminal discovery, they're required to give you some documents through the case. Did you receive the discovery?
Did I receive what discovery?
Okay, have the people provided discovery to the defendant? I don't think so.
Sorry, double checking through the workflow, Your
Sure.
Honor. Yes, it has been provided.
Okay,
What did that consist of?
It never stops amazing me how these room temperature IQ geniuses insist on representing themselves while having absolutely no clue what discovery actually is. Let me clear it up for him. Discovery is the process where the prosecution provides the evidence they intend to use against you at trial. It's not some secret loophole or magic phrase. So, maybe spend less time pretending to be a legal expert and either learn the basics of criminal procedure or hire someone who actually knows what they're doing.
Can you let me know what discovery you provided?
So that would be all the evidence from the case. So that would be reports, just like criminal history. Looks like there is body worn camera available. Basically anything in our case file that's evidentiary would be provided to you. Typically you have to go to the front desk of the DA's office and pick it up because there are large files, so they'll burn it on a CD for you. So if you haven't picked it up already, it's probably sitting behind our front desk ready for you.
Have you picked up that documentation yet?
I've never been given any notice of anything, and
So
the
we
question I have is this so from,
discussions about how to obtain discovery from the district attorney's office.
I object. I don't understand how this court can move forward. I have been very succinct with my motion for discovery.
So
If I understand what you're saying, pardon me, may I continue? Yes?
the way that discovery works is that you are required to go pick it up from the DA's office, okay? So it is not a situation where the court is determining whether the case can proceed. This is not a felony matter where the court is having a preliminary hearing or anything like that. So you have not filed any motions other than the fact that you did not receive discovery. So you know the procedure to get the discovery. You need to go to the DA's office to obtain that.
I'm referring to my motion for discovery, my requests, demands, really. And if I may go back to something you mentioned earlier, Your Honor, respectfully again, if I could have finished what I wanted to read into the record, I come here in peace. But you mentioned that this is not civil, this is criminal. Is that correct?
That is correct.
So there's a crime committed here.
So I'm not going to have these discussions with you, okay? If you want to file a specific motion to have me rule on it, I'm happy to do so. This is not a situation, like I've said several times, where the court is making a determination about a preliminary hearing or anything like that. So you have not filed any motions other than not receiving discovery. I am not going to say that there's no jurisdiction to move forward or anything like that. That is not the situation here, okay? So at this point, you need to go get the discovery from the district attorney's office. I told you that when we set this for trial. If you decide not to do that and don't have that information, that's up to you, okay? So at this point, I'm not going to grant any of your motions because there hasn't been anything that has anything that would have anything to do with a motions hearing at this point. The court is going to deny those requests. We are set for trial readiness on July at 11 o'clock, and then we're set for jury trial on July at 8 o'clock. Trial readiness is the last date that the court will accept any plea agreements. Because you have not filed any endorsement of witnesses or defenses, then you will not be permitted to call any witnesses at trial other than possibly you testifying yourself. You also would not be able to assert any affirmative defenses, but this does not appear to be the kind of case that any affirmative defenses would apply.
I object. I do not consent to this procedure.
You don't have to consent, so.
Absolutely.
I am.
And I object also the fact that I'm being denied my due process rights to read into the record, regardless of what this is.
You can
procedure
file
is called.
whatever you'd like, but I'm not going to sit here and waste court time with you reading things into the record. You can certainly file whatever you'd like. Okay?
I have done that, Your Honor,
I have.
and they have not been answered.
We are not required to answer essentially interrogatories from you. That is not required. So I have denied all of your motions. So we will continue the case then to trial readiness on July 4th at 11 o'clock.
So if I may, Your Honor, you are denying that this court or prosecution has any need or any responsibility to answer my motion for discovery, my affidavit of truth, which are all in writing.
There is no grounds for you to file any affidavit of truth. There is no right to a preliminary hearing or anything like that in county court. So it is not a situation where the court is going to make a determination ahead of time regarding any of the facts. That would be what the jury trial is for.
In my motion, I reserve my right to a trial by jury of my peers.
It's set for a jury trial.
I don't want a jury trial. Why would I want a jury trial? I want a trial by jury of my peers.
It doesn't mean it's your friends and neighbors. It means it is a jury panel in Weld County.
Isn't that what it's supposed to mean?
I am not going to fight with you about this, okay?
I don't mean to
So
fight,
the
Your
case
Honor.
is set for a jury
Posing
trial.
questions.
Okay, so it's time for you to go. I am not going to sit here and fight with you about any of this. All right, the case is set for a jury trial.
That's it for the first case. He has at least one more court appearance before his jury trial, and we'll be covering that as well. Whether the trial itself gets live-streamed is still up in the air, so we'll have to wait and see. Now, let's head over to Kansas for a familiar face, a sovereign citizen I've previously covered in Colorado. Believe it or not, this is the first sovereign citizen I've featured who's managed to rack up the exact same charges in 2 different states. That's almost impressive, if it weren't so ridiculous.
This is in the District Court of Gove County, Kansas, case number 25 TR 687, State of Kansas versus Francis F. Hodge. And you are Francis Hodge?
Yes, the living man, Francis Hajj.
Okay. May I have an announcement of appearances, please?
I'm sorry.
May it please the court, the state appears by Noah Haas, Assistant Gove County Attorney.
And you're Francis Hodge III?
Yes, the living man.
Okay. And Mr. Hodge, it's your desire to continue representing yourself,
Yes, sir.
and you're not requesting counsel?
Correct.
Okay.
Well, I mean, the counsel I have is just not a lawyer. That's all.
Okay. And you do understand the potential punishment for these offenses?
I do.
Okay.
According to your ways, yes.
Okay. By statute, count 2 and count 3, for which you're entitled to a jury, if convicted, you could do up to 6 months in county jail and up to $1,000 fine. Count
Yeah,
1.
that's your statutes. Yeah.
Count 1 is an infraction, a speeding infraction. That's tried to the court, not to the jury. Okay.
Okay.
And that is subject to a fine if convicted.
Okay.
Okay. Now you've requested a jury, and we've got a jury trial scheduled for Monday, June 29th in 2 weeks.
Correct.
Okay, and you understand you have to be here in person in
Correct.
the Gove County Courthouse.
Yes.
Okay. Currently, count 1 is charged speeding 75 and a 70. That's a traffic infraction. Count 2 is failure to provide proof of insurance, a Class B non-person misdemeanor. And count 3 is driving while revoked, a Class B non-person misdemeanor.
Okay.
Mr. Haas, are there any amendments to the complaint or information? I noticed you had filed an amended complaint on June 12th, 2026. It cites the exact same charges, You've just put it into a little different statutory language.
Clarified the subsections, Your Honor.
Have you sent that to Mr. Hodge?
Yes, Your Honor, we did by mail.
Okay.
And I think email too.
Have you received that, Mr. Hodge?
I received it by mail, yes.
Okay. So you're fully aware of what you're charged with, and you're not looking to amend those charges any further, Mr. Haas?
No, Your Honor.
Okay. And Mr. Haas, have you issued your subpoenas to assure the attendance of your witness?
I don't think I've done that yet, Your Honor. I have spoken with the officer. He's aware of the date. I can get that in. I can get that done today.
Okay. I'm sure you get that done.
Excuse me, Judge, and Mr. Prosecutor. Could I get your full names? I do apologize.
Yeah,
My full name is Noah Haas.
Noah Haas. Noah, Noah.
Yep.
And Haas, Haas.
Hahs. It should be spelled out on the Zoom there too.
Well, if it's not spelled out in pictures, you're just going to confuse him even more.
Okay. I'm sorry, what was it? I got two screens up. HA, what?
H as in house. So there's two H's as in
Okay.
house.
HAHS.
S.
Okay, gotcha. And are you bonded as well? Mr. Haas?
Mr. Hodge, that's not an appropriate question at this time. Okay.
What do you mean at this time? What time will it be appropriate?
Well, he is a duly appointed assistant county attorney.
No, I understand that, and every attorney needs to be bonded just like you as a judge.
He's licensed.
No, I said bonded. I didn't ask for a license. I asked if you guys were bonded.
Well, he's licensed. He's sworn in.
Are you required by Kansas statute to be bonded to perform your duties as judicial officers,
We're required to be licensed. We're
but
required
not bonded?
to be elected and or appointed.
But not bonded is what you're saying? You're not
Right.
required to be bonded?
Right.
Okay.
Okay.
And what was your full name again, Judge? I'm sorry.
Just like it says on the screen, Thomas J. Dries.
Yeah, I'm on two screens, unfortunately, on the Zoom, and I can't see that part. I'm typing on my notepad here. Can I go ahead and get your name for the record?
Yeah, Thomas J. Dries. Okay. Mr.
All right,
Hodge,
thank
have
you.
you sought discovery and inspection in this matter?
I'm sorry, how about what?
Have you sought discovery and inspection?
Have I sought discovery? Yeah, I'll present everything at trial.
No. Have you
I-
sought discovery from the state?
Oh, have I sought discovery? No, I don't see a point to seek it because it's already presented.
Mr. Haas, have you sent any discovery to the defendant?
Your Honor, we have not received any requests for discovery, nor have we sent any discovery materials.
Okay. And have you requested reciprocal discovery?
No, Your Honor.
Mr. Hodge, do you intend to set forth any objection to the institution of the prosecution?
Oh, of course, I do have objections, but being that we already have the trial date already in place, It wouldn't do any good to try to do anything before the trial because we're not going to get anywhere.
Okay. So you're not alleging any defects in the complaint?
I'm sorry. Can you, what is that in like plain English? Any defects and complaints? Are you saying, do I disagree with any of the charges?
No, I'm saying, are you alleging that they have charged the wrong crime? Have they charged the wrong date? Have they charged the wrong jurisdiction?
Oh, the wrong crime for sure. Jurisdiction, I'm still up in the air. I'm not sure about, but yes, the wrong crime. Yes.
Okay, you don't believe you were in Gove County?
Oh, I didn't say that. You know, I mean, I got pulled over in Gulf County, so we know I was in Gulf County.
Okay. Are you claiming any violation to your right to speedy trial?
No, I think this is speedy. I have no complaints against that part.
Are you claiming any alibi?
There's no alibi to be had.
Okay. Are you intending to file any motions to suppress during the trial?
I won't know that until the trial.
The trial is when the evidence will be presented against you. If you want any of it thrown out, you'll need to file a motion to suppress before the trial starts.
The trial is set for June 29th. It is one day. It is a six-person jury. Each side has three peremptory challenges. So we will qualify 12 jurors and strike down to 6. Okay. And does either party anticipate filing any motions in limine?
And what?
Motions in limine, which is,
Okay.
that's
Yeah.
a motion to limit what can be presented.
Oh, no.
Yes, Your Honor, I do intend to file a motion in limine
Concerning,
concerning anticipated meritless legal arguments.
What does that mean?
such as what?
Arguments that Kansas lacks jurisdiction over the defendant, uh, arguments about being a secured party, traveling, not driving, jury nullification, arguments about the judge, the court, or the state being corporations, claims that statutes only apply upon consent of the defendant.
Why would you limit that?
How long do you anticipate needing to get that on file, Mr. Haas?
Believe I could get it filed within the next couple days, Your Honor.
Okay. Can you do it by the end of the week?
Yes, Your Honor.
Okay.
Would that filing be ruled as okay to have those limits?
We'll take that up at the time of at the start of the trial. We'll take
Okay,
those
because I
up.
would need to know that before the trial. Because if those kind of limits are there, then basically it sounds like you guys would be violating my constitutional and civil rights if it's accepted.
Well, we'll take those up at 8:30 in the morning on the 29th.
Well, a part of me showing up, I could take a warrant, but I think it would be more fair if that is known ahead of time, because there won't be no sense in me playing those kind of games if I'm unable to bring the fullness of what I may bring, what I have to bring, representing myself to the table. There shouldn't be no limits. You should be able to hear everything, especially when it comes to the law.
Well, he's filing his motion by Friday
Mhm.
at noon.
So should I file a motion to have no limine?
If you wish to file a response, you must file that by next Wednesday at
Okay.
noon.
All right.
I'll make sure I email you immediately after filing, so you should have enough time. As well as we'll mail it out too.
And can I also get your email so I can file as well?
I have sent you some correspondences, so you might be able to find it, but it's Noah. That's Noah.
Okay. Now I'm talking about to the judge. You said you was gonna
Oh.
email the judge.
I'm going to email you the motion right after it's filed, so you have as much time as possible.
Okay, I appreciate that. But I would also like to file my motion to the judge just like you. I
Well,
just need an email if that's okay.
You'd file it with the court.
Okay, and what's the court's email? And you need that motion in by next Wednesday, you said? Or-
Yep, by noon on the 24th.
Okay. And what is that called again? A motion of limity?
Motion in limine,
Oh, in limity. Okay, thank you.
Limine,
Limine.
INE.
INE. Okay, got it. Thank you. Okay, all these extra steps is interfering with my work. So how can we limit some of these steps so I can stop missing work? Or can I just charge my time from work off to the courts?
No, you can't bill the court simply because you chose to represent yourself against criminal charges that stem from your refusal to follow the same laws everyone else is expected to obey.
Well, you can't charge your time to the courts, but Mr. Haas will file the motion in limine. You'll have a chance to respond to it. You want a hearing prior to trial, so at your request, we're setting a Zoom hearing at 10 o'clock Friday.
I didn't request anything before the trial. I just asked
You're
about the motion.
requesting the court to rule on the motion prior to trial.
Okay. Oh, that's what you're saying. Okay.
That's what you just
And that
requested.
means right. And I have to miss work for this small period of time for that is what you're saying?
Yes, you'll need to appear at that hearing because you've requested the hearing on the motion in limine. So we'll
Okay.
have that on the 25th at 10 o'clock.
Okay. Yeah, I got you. I just wanted to be clear. I want to
Okay?
make you have an understanding.
And
Appreciate it. Thank you.
then you'll be here for the trial on the 29th. Okay?
Okay.
Are there any questions of law that either party think will arise during the trial?
I think Mr. Haas and I, we already had such a discussion and it led to nowhere. So I have that's the only reason for the motion in limine for on my end.
Okay. Mr. Haas?
Your Honor, the anticipation of any matters of law has already been outlined in my request for the motion in limine. I don't see, unless without defendant letting us know now, I don't anticipate anything that I haven't already mentioned.
Okay.
And also too, I don't know anything vice versa. You haven't let me not know anything either. So we're both in the same boat.
I suppose, Your Honor, that I do have a motion. If it's filed too late and we're not going to hear it, that's fine. But I suppose that's an additional issue of law that's pending.
What is that?
So I did file a motion to reconsider for bench trial. I do believe the law supports that. You did make a ruling on it already, but it was based on the lack of a written request for jury trial on the defendant. And I mean, I kind of lay it all out in the motion, but
But the judge granted it.
Yeah.
He said there was no need. I didn't need to.
Hang on, Mr. Hodge. Let me speak.
Yes.
The purpose and requirement of that, Mr. Haas, is so that he doesn't show up at a time of a bench trial and say, hey, I want a jury trial. So you have to make your request. He made his request to the court in person, which is as good as filing it in writing. So the court heard his request for jury, and he's entitled to a jury on counts 2 and 3. So
I'm happy. I'm okay with that, Your Honor. I disagree, but I'm 100% okay with your ruling. I object. It's all in the motion.
that's fine. And you've got your objection noted for the record. And if at an appropriate time you wish to take that up with the Court of Appeals, you can do that. Okay?
Gotcha, Your Honor.
Okay. So exhibits, the state, your exhibits will be using numbers, 1, 2, 3, etc. The defendant, Mr. Hodge, if you have any exhibits you're going to file, they must be filed using letters. Exhibit A, Exhibit B, Exhibit C, etc. Okay?
Write that down as well.
Is there any
Okay, got it.
technology or media anticipated at trial by the parties?
Possibly, but it depends on me presenting the exhibits, which I will have photocopies of for everyone.
Your Honor, I do anticipate showing video.
Okay. You must work with the clerk to make sure that you have the appropriate technology in the courtroom and available.
Yes,
Okay?
Your Honor.
Okay. Test it out, make sure it works.
And when you say appropriate, what does that mean exactly? Like if it's on my phone, I need to have that connection or that Bluetooth or Wi-Fi or something connection with the courts.
Well, if it's on your phone, that's a bad thing because then your phone will be taken into evidence. If you're going to admit something, you need to put it on a medium that can
Oh,
be
like a drive.
trial. Yes, like a drive.
Okay.
Okay.
All right. Thank you. Yes. Yes,
Okay.
Your Honor.
Do either party anticipate any issues with the jury instructions?
No, Your Honor.
I don't know what the instructions are.
Okay.
Can I get that in writing and mailed to me?
Oh, boy. He's in serious trouble if he doesn't even realize jury instructions have to be submitted before the trial begins. It's hard to understand why someone would insist on representing themselves when they seem so determined to remain confidently uninformed.
Well, it's your obligation to provide any proposed jury instructions you wish to have to the court. Those are the pattern instructions of Kansas.
And I could get those through the clerk's office there.
Well, you'll have to get it online. I mean, you certainly can come into the clerk's office and look at them, but it's a
Okay.
large volume and they're not going to copy it for you.
Okay. And you said online, where do I go to get
Just
that?
look up pattern instructions of Kansas through the Kansas Judicial Council. Any proposed instruction should be cited by number. If you have any requested changes, you must cite them by producing the instruction with the cited change. And Mr. Haas, on your element instruction for counts 2 and 3, make sure you go ahead and submit your element instructions because there are options you have to choose. Okay? And
Yes,
Okay,
sir.
my charges were what exactly again? Speeding.
the speeding is tried to the court, so you don't have to worry about the speeding. The
but,
two that are tried to the jury are
Mhm.
no proof of liability insurance.
Okay.
That's count 2, and count 3, that you were driving when you were revoked.
Okay. All right, thank you very much. And that's count 3.
That is count 3. And Mr. Haas, on your amended complaint, you're still indicating canceled, suspended, or revoked. It's not in the alternative. Which one is it?
Suspended, Your Honor.
Was he suspended versus revoked?
I believe so, Your Honor. I'm not 100% certain.
Okay, well, you'll need to, at the time of trial, will then narrow it down to whether it is suspended or revoked. That is not an alternative charge.
Yes, Your Honor.
Okay. So any proposed instructions the parties wish to submit to the court must be submitted by June 19th at noon.
Okay.
Again, if you're just requesting an instruction as it is printed in PIC, you just have to give us the number of the PIC instruction. And Mr. Haas, on your element, go ahead and prepare your element instructions for counts 2 and 3. And
Yes, Your Honor.
Okay. Okay. Get your motion in limine filed and your jury instruction filed, Mr. Haas. Mr. Hodge, make sure you respond by next Wednesday at noon.
The 25th by noon.
No, you have to respond on the 24th by noon.
Oh, 24th by noon. Oh, I'm sorry.
You'll
Yep,
have a
24th.
hearing on the 25th at 10 a.m.
Right. No, I have that. I apologize.
Okay?
Yep. Yes, sir. Appreciate it.
Okay.
Mhm.
Thank you all.
All right. Thank you as well.
That's the end of today's video. Both of these defendants still have court appearances coming up before their jury trials, so there's plenty more to cover. Be sure to stay tuned for those updates. If you enjoyed the video, give it a like. If you didn't, hit the dislike button. Either way, leave a comment below with your thoughts, and don't forget to subscribe and turn on notifications so you never miss a new upload.